Here is the case brief of Salomon versus Salomon. This case explains a separate legal entity concept in business. These are the characters in Salomon case.
Hi, I am Mr. Salomon.
And I am Salomon's wife.
Hi, we are Salmon's sons.
And I am the only daughter.
Hi, I am the liquidator.
Hi, I am Broderick and I am the creditor. Salomon is a sole proprietor. He is running a leather business in 1982. Salomon's wife, 4 sons and a daughter need shares from the business. We need some shares from the company.
Okay, I will form a company and give all of you one share for each.
The company Salomon & Co. become a separate legal personality on receiving its certificate of incorporation. Salomon then agreed to sell his shoe business to the company for $39,000. The shareholders of the company agreed to the price asked. Salomon was paid $10,000 in cash, was given 20,000 shares worth 1 each and a debenture for the remaining 9,000 owned by him by the company. The company was running well. As the time went by, the company faced difficulty, and in order to raise capital for the company, Salomon sold his debenture to Broderick. The cash raised was used for the business but did not manage to stop the company from facing more problems. Finally, a liquidator was appointed by the creditors to realize the assets of Salomon & Co. and settle the debts owed to the creditors. However, when all the assets of the company were realized, the total amounted to around 6,000. The creditors were horrified to find out that the money was to be used to pay off the debenture, as the creditor holding it was considered a secured creditor. The case was taken to the courts, and the High Court held that the creditor could not recover their debts as their contracts were with the company and not with Salomon. However, on the Court of Appeal, it was held that since Salomon was the majority shareholder, 20,001 shares as compared with a negligible remaining 6 shares, and he was also a director of the company, that the company therefore belonged to Salomon and that he should be liable to settle all the debts owing to the creditors of the company. On further appeal to the House of Lords, it was held that Salomon & Co. is a company and therefore had separate legal entity. It could not be said that Salomon owned the company. The company and Salomon are two legal persons in law. It is the company which has the power to enter into contracts. Therefore, debts of the company are the responsibility of the company and not its members. It is the company which entered into contract with the creditors, and the creditors can only sue the company and not its shareholders. Salomon liability as a shareholder is limited. Separate entity principle is a fundamental principle of a company law applied on a global basis. Pursuant to this principle, a company is treated as a distinct entity from its members. This means that most of the legal entity in business is separate from another business or individual with a value to accountability. Besides, the example of a corporation or a limited liability company is found in a separate legal body. This is because the corporation tend to separate the action of an entity from those of the individual or other company. The separate personality of a company as distinct from its shareholders was established by the House of Lords in Salomon versus Salomon Co. in 1987. Once a company is incorporated, some of the consequence would be flowing from the application of the separate identity principle. The main consequences include distinction between private and company debts, distinction between private and company assets, company contracting with its members as employee and director, and company liable in tort to a member. The debts are undertaken into company's name is belong to the company as well as not to the controller or director or any other else. This is confirmed by the House of Lords when made a decision in Solomon's case. In this way, the debt or liability are liable by the company due to the separate legal person. However, there have some exceptions in certain circumstances, that is, common law can be modified by the statute law. Assets purchased by the company's name are belong to the company. It does not belong or own to the directors, shareholders and other else, even though the shareholders who own 100% of the shares also do not have the right to own the asset of the company. This is because company is a separate legal entity and can own property in its own right, which means the company is legal owner with ownership right to the property. The case of Makora vs. Northern Assurance Co. in 1925 shows that the company owns its property separate from the property of its members. A company as a separate legal entity can enter into contractual relation with the shareholder or director due to they are company controlling members. This can be illustrated in the case of Lee vs. Lee Airfirming in 1961. This case shows that the company could enter into an employment contract with Mr. Lee, Lord Morrison, as he is a major shareholder of a company. The shareholder have limited liability mean that the condition by which shareholders are legally responsible for the debts of a company only to the extent of the nominal value of their shares.